you both with us. I would like to obviously just give thanks from our end to you guys for really joining us and presenting on a most amazing topic. I think I am so passionate about medmal. I truly love, breathe it, and I'm sure both of you have been doing this for many, many moons. And it's something that I think both of you are passionate, and we've had so many discussions about it. Both Bryce and Deniro are at Norton Rose Fulbright. They're actually in the KZ in practice, and they actually both work specifically in public health sector as well as in private. They both are obviously passionate, like I said, and Bryce as well as Deniro has focused on the construction industry as well. Deniro has headed up the team for quite a few years, and a panel of esteemed attorneys, specifically obviously focusing on medical malpractice as well as government work. Bryce, the handsome young man on the call as well, thank you so much for joining us. It is an absolute pleasure. And over to you guys. We will be dealing with questions after, so please chat it into the channel box as well as on Teams as well as Zoom, and we'll take it from there. Thank you, guys.
Thank you, Fia. Welcome to all of our brokers and to all of our colleagues and friends who join us from week to week on iTuesday. Thank you for joining us on this chilly morning. It's so good to have Deniro and Bryce joining us this morning. As you know, we really are in the throes of the third wave, and these topics are top of mind with the medical professionals at the forefront, dealing with the chaos that comes along with COVID-19. So we're very much looking forward to hearing what they have to say. And remember, please put your questions in the chat box, put them as all panelists and attendees so that everyone can see your questions, or you can put a question in the Q&A. But I'll leave it to Bryce and Deniro to wow us with the information that they have for us this morning. Thank you, guys.
You get a second chance at life, and we get to be the architects of your second chance. It's win-win.
What's going on?
When it works.
Meredith?
There isn't enough tissue. I can't close.
Good morning, everyone, and thank you to the I2 team for the warm welcome. What the video clip illustrates is that even with the best preparation in the world or with the best medical team, sometimes things go amiss during surgical procedures and medical treatment. And a doctor is not to be held negligent simply because something has gone wrong. And this position has been recognized by our courts. In the Supreme Court of Appeal in 2013, in the matter of Buthelezi versus Ndaba, the court held that the human body and its reaction to surgical intervention is far too complex for it to be said that because there was a complication, the surgeon or the doctor must have been negligent in some respect. Now, we are facing as a country the pandemic of COVID-19 over the last year, but from a healthcare sector perspective, we have been facing another pandemic over the last 5 years, that pandemic being called medical malpractice claims. And to contextualize it, currently the National Department of Health and its 9 provincial departments are facing contingent liability in excess of 100 billion rand. And medical malpractice claims has been cited as one of the greatest risks to the failure of our public healthcare sector. And to sort of give you an example, Bryce and I act for the KZN Department of Health. And let's just take Hospital A in one of the rural areas is given a yearly budget of 100 million rand to run the hospital. And ultimately, there's a medical malpractice claim where the MEC is found liable for an event that occurred at that hospital. And then a judge orders 15 million rand to be paid as an award in relation to that event. What then happens is that 15 million rand is taken out of the budget of that facility. So now what you have is a facility that is meant to have a 100 million rand budget to run is now down to 85 million rand for a year. And what that then does is just adds on to this vicious cycle of service delivery and providing healthcare at a reasonable level. So the difficulty we have is there is no set budget from National Department of Health for its provincial departments in relation to the settlement of medical malpractice claims. It's something that we are ongoing in development with the National Department of Health insofar as setting up a type of funding scheme so that we can allow hospitals to actually use their budgeted funds for the use of providing healthcare services. And the private sector has not fared much better. To give you a sample size, Bryce and I act for various private hospital groups and practitioners in KZN. Between the two of us on our sample size, we are defending contingent liability of about 4 billion rand. Now, if you take our sample and then sort of adopt it to the various provinces and various other regions in South Africa, you can imagine what the type of numbers that we are dealing with. And you as the insurance industry have seen the effects of this. There are certain sectors of medical practice that's virtually becoming uninsurable. Further, there have been both international and local insurers that are no longer insuring that risk. In South Africa, I recently had a conversation with a Spanish-based insurer regarding medical malpractice, and they said that they don't view South Africa as a viable option at this stage because the market is too volatile as perceived overseas.
So what's then driving this medical malpractice pandemic? There are various factors, but one could just look at the nearest street signpost or billboard and you would see an advert for a plaintiff's attorney eager to take on these sorts of claims on a no-win, no-fee basis. And whilst this is a significant problem, it's not the only issue driving the pandemic. There's certainly an increased public awareness of the potential to institute and pursue these sorts of claims. Yes, there's aggressive marketing and pursuit of plaintiffs by personal injury or plaintiffs' attorneys in looking at these sorts of claims. And also there's been a recent addition in terms of a new player in the field around litigation funders. And perhaps some of you may have come across perhaps the best known example of this in the Vodacom Please Call Me case. But they've also sought to be involved in matters such as the silicosis class action matter. And I'm sure as things go forward in the future, we'll see them playing a greater role in this space than before. And it will be interesting to see how that unfolds because you've got a situation presently where largely you're dealing with individual plaintiffs and their interests as individual litigants in the matter in achieving reasonable compensation, whereas litigation funding is perhaps a different prospect in that you're looking at an entity that has a commercial interest in ensuring the highest recovery or the most significant award possible. Another driver that's been suggested has been a perceived decline in the personal relationship between medical professionals and patients. And it's really a vicious cycle because on the one hand, you've got practitioners that are concerned about the potential for claims against them, and perhaps they're more cautious in their engagements and what they share with their patients, which in turn leads to patients having a level of distrust towards those practitioners where there's a sense that they're not being told the full picture. And as a result of that, those patients are perhaps more willing or open to pursuing claims against those practitioners. Changes in legislation have played a role. Many attorneys that previously dealt with road accident fund matters have moved to greener pastures, so to speak, in pursuing medical malpractice claims. And technological advances have also played a role. To use perhaps quite a good example in terms of birth injury cases, there's now a widespread use of CTG tracing or CTG monitoring in maternity wards across South Africa. And that monitoring enables plaintiffs' attorneys to pinpoint to a far greater degree than before the timing and the manner in which fetal distress unfolded in the course of a labor, ultimately leading to a point where they can criticize a failure to act in response to those signs on the part of the nurses or medical practitioners involved. In terms of consequences and the fallout of the medical negligence pandemic, they're quite varied, but perhaps the most obvious one is an increase in insurance premiums. Obviously, where you've got an increase in the frequency of these sorts of claims as well as their value, the premiums involved go up accordingly. Practitioners also are more inclined to practice their medical profession defensively, and that's really to order extensive testing that perhaps isn't necessarily strictly required in the circumstances, more with their own risk in mind than the patient's best interests. These two consequences have a knock-on consequence of ultimately increased costs for the patient in accessing and utilizing healthcare services. Additional consequences, Deniro has dealt with the volatility within the market and the fact that many major players are either pulling out of the space or are hesitant about entering into it as a result of the significant risks involved in covering these sorts of issues in the medical field. There's also been an impact in terms of a shortage or skills shortage in high-risk specialities. And perhaps the best example of this is in obstetrics, where the cost of insuring oneself in that space and the risk involved, particularly in terms of birth injury claims, is such that many obstetricians have opted, rather than to proceed with their obstetrics practice, instead to focus on the gynecological aspect of their practice, which poses a significantly reduced risk to them. And this has again had a knock-on effect in terms of accessing the services and medical services. And Deniro has touched on the huge challenge this is in the public sector, where you have amounts from the hospital's budgets being allocated to payment of these sorts of claims, when in fact it should be covering the provision of services. But we also are aware of at least 2 private hospitals where the maternity units have been closed down because of a lack of availability of obstetricians to service them. So it's not a unique public sector challenge, but also one that is starting to spill over into the private sector too.
So what are the legal consequences for a medical practitioner from a single medical malpractice event? So firstly, you have civil litigation in the form of a medical malpractice claim. You have professional misconduct inquiries by the professional regulators. You have inquests where the patient has passed away due to unnatural causes. Criminal proceedings, generally in the form of culpable homicide. And we've seen in the press in recent years that there have been proceedings against practitioners in this regard. And a practitioner can be a subpoenaed witness in all of the above proceedings. So today we're going to be focusing on 2 insurable risks: civil litigation in the form of medical malpractice claims and professional misconduct inquiries. So starting off with civil litigation in the form of medical malpractice claims, these claims can either proceed in terms of contract or delict. But as a general principle, we see them in delict. The reason for that is a claim in contract is limited to patrimonial losses only. So in other words, you can only claim for what we call special damages as opposed to general damages. Hence, most of the plaintiffs proceed in terms of delict. There are 2 main issues that we look at. It's liability and quantum. I'll be covering the liability part and Bryce will be dealing with quantum. So dealing with the 5 elements to prove a delictual claim, you have wrongfulness, fault, and with medical malpractice claims, it's generally in the form of negligence. You have conduct, either in the form of an act or admission, causation, which is both a factual and legal test, and harm or loss. So what you're looking for is whether the doctor's wrongful, negligent act or omission caused the patient to suffer a harm or loss. So with medical malpractice claims, from a defense perspective, we focus on 2 elements. We focus on negligence and we focus on factual causation. And this is what we deem causal negligence. So the first inquiry is negligence. And then the second inquiry is, did that negligence cause the outcome? So in determining negligence, the court has developed what they call the reasonable medical practitioner test. And the test is if the reasonable practitioner in the position of the defendant doctor would foresee the reasonable possibility of his conduct injuring his patient and causing her patrimonial loss, would have taken reasonable steps to guard against such occurrence, and the defendant doctor failed to take such steps, then the defendant doctor would be found to have acted negligently in the circumstances. So to contextualize that with an example, we'll make Bryce the doctor and make myself the patient. So I go in for surgery to my left knee, but I come out with surgery to my right knee. Now, applying that test, the reasonable orthopedic surgeon in the position of Bryce would foresee the possibility or the reasonable possibility of his conduct on operating on the wrong knee, injuring me and causing me patrimonial loss, would have taken steps to guard against such occurrence. Now, what would be the steps in that context? Well, firstly, it's expected for an orthopedic surgeon to have what we call a preoperative meeting with the patient, where you'd meet the patient, have a chat, confirm which limb is being operated on. That sometimes takes place in theater before the patient is in fact put under general anesthetic. Another way to mitigate the risk would be the orthopedic surgeon shaving the limb that it's going to operate on as an identification marker, alternatively physically marking it with a marker. And in that context, Bryce failed to take those reasonable steps, so therefore Bryce would be held to have been negligent in those circumstances. Now, the courts have also said that if the error is one which a reasonable competent practitioner might have made, it will not amount to negligence. And one of the sort of matters where we see this is, for example, where there's a laparoscopic removal of the gallbladder, and you have a patient that has the visual fields being obstructed. Sometimes you find that during a laparoscopic procedure of that nature, it's common to have bile duct injuries, either to the common bile duct or the other ducts. And in those circumstances, if you could show that the reasonable practitioner in those circumstances would also have injured a bile duct, then you could run this defense. However, as a defense lawyer, and I'm sure I too as your insurer, we're not keen to run this type of defense. In other words, you're saying, oh yes, I made a mistake, but don't hold me liable because another doctor would have also made the mistake. It's not the type of defense you'd like to be tested in court. So once you've established negligence, the next test is factual causation, or what we call the but-for test. In other words, but for the negligence, the harm would not have been caused or been avoided. And an example of this is a case where I acted for a private hospital group, and a child was delivered, but the baby was born with a low blood glucose level. The pediatrician immediately ordered that the nursing staff provide the baby with certain feeds in order to stabilize the blood glucose level. The child was transferred to the maternity ward of this hospital. However, the nurses forgot to give the child the feeds as ordered by the pediatrician. And about 4 hours later, the child was found to have very low or dangerous level blood glucose level, which is what we call hypoglycemia. The baby was immediately admitted to neonatal ICU and provided with feeds intravenously. And within an hour, the blood glucose level stabilized. Ultimately, the baby was discharged from hospital, and a few years later, there were issues of a cognitive nature. And what then happened is the parents sued the hospital on the basis that the child had suffered brain damage as a result of the hypoglycemia, and that brain damage had manifested itself as cerebral palsy. So with a team of experts consisting of a pediatric neurologist, a pediatric neuroradiologist, a pediatrician, and performing genetic testing, we were able to establish that in fact, the blood glucose level was not low enough for long enough to have caused a hypoxic brain insult of that nature. And in fact, that was evident on the MRI brain scans. ultimately, we were able to establish on a balance of probabilities that brain insult was in fact caused by an inborn error of metabolism, alternatively a genetic disorder. And what you find in that case is that the nursing staff were clearly negligent, but that negligence did not cause the harm suffered by the child, which is the brain damage. So where does it go wrong in medmal claims? And over the years, we've seen the failure by both doctors and nurses to perform regular assessments and examinations of patients in accordance with the protocols, either the protocols of the specific hospitals, alternatively, the protocols issued by the regulator or the Department of Health. The failure to record the notes of the assessments of the patient, and that has a consequential impact, because if Bryce does an assessment in the morning and doesn't accurately record the notes, then the staff that comes on in the evening, or the doctor that comes on in the evening, he is not aware of issues that may have arisen that morning or throughout that day. We find that doctors rely solely on the information provided by the nursing staff. In other words, providing treatment telephonically, rather than doing the job of actually physically assessing the patient. And the courts have taken a dim view of this type of behavior, particularly in the private sector. In the private sector, the courts have specifically held that the doctors, the patient is the doctor's patient, it's not the nurse's patient. So there's an expectation that the doctor provides regular assessments of the patients. Another big issue is doctors allowing nursing staff the discretion to act outside their scope of practice. So that may be administering certain types of scheduled drugs, dealing with the titration of those drugs, insertion of certain types of catheters. So it's very important that doctors do what they are trained to do and nursing staff do what they are trained to do. We also see a lack of communication between nurses and doctors, and the so-called fear of nurses to contact doctors in the early hours of the morning. You know, Bryce and I have consulted over the years, and you get, oh, so-and-so is a terrier, and, I was afraid to call him. So I tried to wait for an hour more to see if there, any interventions can help. And then Mr. Terrier, you put him in the witness box, and then he'll say, if that nurse had just contacted me, I would have put on my gown and I would have been down there within 5 minutes. So everybody blames everybody when there's an issue. So I think rather phone the doctor and deal with the consequence of an unhappy doctor at 4 o'clock in the morning than a poor outcome for the patients. But, I must say, having seen it over the years, we have developed, based on our experience, protocols in the private sector. And identifying these types of risks, we have seen, I would say, in the last 5 years, a significant decrease in valid claims in the private sector. So whilst we continuously see an increase in claim and claim value, we've definitely seen a decrease in the private sector of valid claims due to the fact that we've taken this type of information and we have implemented risk protocols for hospital groups in conjunction with their clinicians that are employed by the hospital groups. So generally, once you have proven causal negligence, liability is established. The next step then is the issue of quantum. In other words, the determination of the value of the loss or damage of that patient.
In looking at what the award value in the context of quantum should be, you really, in terms of medical negligence matters, are looking at 4 main heads of damages. The first is past medical, hospital, and related expenses. And that's generally a calculation exercise where you look at the expenses that have been incurred by the plaintiff previously up until the point of the award at court. And it's a question of looking at invoices, statements, proofs of payment, etc., and a determination of whether the costs incurred were reasonable, and that's the figure you reach. Future hospital, medical, and related expenses is the next category, and that's a little bit more of a prophetical exercise in terms of anticipating or reaching some kind of an estimation about what, firstly, the further future treatment of that patient might be, and then the costs associated. Then the third category is loss of earnings, and that's where, as a result of the medical negligence and the injuries concerned, the patient or the plaintiff has suffered either a loss or a reduction in their earning capacity. Finally, you would look at general damages, and this category deals with the more intangible damage that's suffered by a patient or a plaintiff, and that's things like pain and suffering, loss of amenities of life. So that's if you were a keen sportsman or sportswoman before your injury, but that's been deprived of you after the fact, there needs to be some kind of compensation. And then also you'd look at things like disfigurement and disability in determining the value involved. There's a multiplicity of factors you'd look at in trying to determine damages in each of those categories, but perhaps the most important ones to look at, the firstly is life expectancy. It goes without saying that the longer the plaintiff or patient can be expected to live, the longer you need to provide for expenses, loss of earnings, etc. You'd also then look at the extent and nature of the injury and physical disability. That's important, particularly in terms of the sorts of medical intervention that you'd be looking at. And then duration of the effects of the negligence or the injury concerned. And for example, if you're looking at a claim where the pain and suffering experienced by the plaintiff was a matter of hours as opposed to for life, then this award for general damages to cover that head would be a lot smaller than obviously if you're looking at pain and suffering over a lifetime. Employment and education history, that you'd look at if it's the plaintiff themselves that has been injured, you'd look at what their pre-morbid or pre-injury condition was in terms of their employment status and their educational history. Where you're dealing with a minor child that hasn't completed schooling and entered the workforce, you would look at the family, particularly the parents and siblings, but also if that's not possible or provides limited insight, then you'd look at extended family, uncles and aunts and cousins. Looking then perhaps at a good example of how quantum has developed in recent years is to focus on a case of Singh versus Ibrahim that was dealt with in the Supreme Court of Appeal. And here the claim related to a cerebral palsy minor child and a representative claim brought by the parents. And prior to 2010, we typically saw cerebral palsy awards or claim values sitting between 5 to 7 or 8 million rand. In the Singh case, the claim value was incredibly high at 51 million rand, and the trial on quantum ran down here in Durban, or in KwaZulu-Natal rather, for a period of 12 weeks. At the end of that trial period, the High Court awarded a total of 9.5 million rand in favor of the plaintiffs. They weren't happy with that award and ultimately took the matter on appeal to the Supreme Court of Appeal in Bloemfontein. There, the award value was just over 12 million rand plus costs, which equates to a 2021 value in excess of 20 million rand. Part of the reason for the plaintiff's success in dealing with the matter, both at trial and then ultimately on appeal, was relying on a full suite of experts that commented on the costs and the treatment required in their various areas of expertise. And the list that you can see on screen there is a typical experts list, if I can call it that, in a cerebral palsy matter, ranging from life expectancy experts through to actuaries and mobility consultants. But what has happened as a result of the Singh case and developments thereafter has been that the principles that were utilized in that matter have been applied not just in cerebral palsy matters, but in medical negligence matters across the board. And for example, whilst this list relates to a cerebral palsy matter, if you were looking at an orthopedic case where there was some kind of an orthopedic injury, you could still expect to see an orthopedic surgeon being required, a physiotherapist, perhaps an occupational therapist, an orthotist, a mobility consultant, and an actuary. So really all that has happened is plaintiffs have utilized the suite of experts tailored according to the nature of the claim to increase and argue for a bumped up quantum in many of these matters, which has resulted in increased awards at the end of the day. And whilst as a skeptic, or particularly as a defendant's attorney, you might have your views about this. Ultimately, at the end of the day, the aim in quantum is to place, as far as reasonably possible, a plaintiff or the injured minor child, as you would see on screen, back in the position that they would have been but for the injury or the incident concerned. And as much as there's a significant cost involved, where it can be shown by a plaintiff that a buggy, providing a buggy such as the one in the video, would serve to improve the quality of the minor child's life, I think you'd be hard pressed to persuade a court to find otherwise. So after the Singh case, we now see in cerebral palsy matters, claims typically sitting between, or claims and awards sitting between 15 and 25 million rand. But it's not just in the cerebral palsy matters that we've seen this sort of an increase. In terms of other settlements or awards or claims that we've been dealing with recently, we recently settled a matter where a nephrologist left a dialysis guide wire in place in a plaintiff, and there we settled at 100,000 rand, and that was largely in general damages. 3 million rand for a postpartum psychosis injury where a mother jumped out of a window of a hospital and severely injured both of her legs. There, quite a large component of the claim was loss of earnings, but the medical expenses, both in terms of further orthopedic intervention, physiotherapy, etc., also made up a significant portion of that claim. We were also involved in a matter where we successfully extricated the insured we were involved with from liability, where a pilot who was earning in US dollars suffered a brain injury in the course of a procedure at a private hospital. And ultimately, the claim there sat at 40 million rand because of the significant earnings that the pilot had at the time through earning US dollars. We weren't involved with it, but we were on the fringes of a further matter where a family businessman experienced a brain injury, and there the claim was sat at 100 million, and that was because the patient was earning a non-market related salary in a family business. And ultimately, the matter was settled at an incredible figure of 40 million rand, largely because of the situation where that loss of earnings made up the bulk of that claim. But it's worth bearing in mind as a general comment in closing on quantum, that you're not dealing with small numbers as a general proposition. And Deniro and I were involved with the case for an obstetrician where he had the incorrect category of cover. We were fortunately not for the obstetrician, but involved for the private hospital group concerned. And ultimately, the cover was refused, and the obstetrician faced a claim in excess of 20 million, which at the end of it, when settlement was achieved and all was said and done in terms of legal costs, cost him about 15 million rand. So in closing on quantum, you really need to be careful that you ensure that you've got the correct category of cover and that you've got the correct insurers involved, small punt for I2, so they can look at appointing attorneys and a team around the practitioner to advise and guide them in dealing with these sorts of claims to ensure the best outcome possible.
So before I move on to this slide, one of the other things emanating from quantum as well is we've seen some weird and wonderful claims over the years. As Bryce showed, a buggy for a CP child with a particular type of cognitive ability is reasonable. But we've had claims from everything from the insertion of an Olympic-sized swimming pool at our house to horse therapy, and we've, as I say, some categories of claims that is mind-boggling. So again, it's what is reasonable to put that particular child or that particular plaintiff in the position they would have been in had the harm not occurred. So looking at medical malpractice litigation challenges in a COVID-19 world, maybe taking some of you back. I remember watching this movie as a kid, but we are going to be looking at the good, the bad, and the funny. So dealing with the good, I also tend to have some dinosaur tendencies. I have not gone paperless. I know the trees don't take kindly to me. And as a litigator, I think when lockdown happened initially, I had a bit of anxiety as to, what's going to happen. We need the courts functioning, we need offices functioning. And what the pandemic has showed us is that we have the technological framework and the internet capabilities available, that you can litigate efficiently and fully with the use of technology. And we've been able to consult virtually with no problems, and it's been hell of a useful. We could have a consultation with me sitting in Durban, a nurse sitting in Johannesburg, an expert sitting in Stellenbosch, and an advocate sitting in Cape Town, and run it as if we were all in the same room. That has impact seriously on litigation costs because, you've killed the traveling time, having people to fly in, fly out for trial prep consultations, etc. We've also seen litigation processes being moved electronically, the serving and filing of documentation electronically on your opponents as well as the courts, which illustrates that we can move towards a paperless system in the future. And lastly, we've had court hearings being run virtually, both trials and opposed applications. And what this also means is that you could now have the best lawyer, regardless of province, provide the service to you in the different provinces. So Bryce and myself, Bryce had a trial in the Eastern Cape, which he ran electronically. I've had a couple of matters out of the Gauteng courts electronically. So I think the cost benefit, as well as being able to use who you want to use in these types of matters, is one of the great goods out of the advancement of technology and the use of technology insofar as litigation. But, the Constitution says everyone is equal before the law and everyone should have access to the courts and the court systems. And we do know we are a country where everything is not equal. So I'll leave it to Bryce to deal with some of the effects under the bad section in relation to technology.
Yes, unfortunately, the use and application of technology hasn't been uniform. In many divisions, despite perhaps in Gauteng being the best example of where it's worked, in many divisions, unfortunately, electronic hearings are still not taking place. This is the position in KwaZulu-Natal and to a lesser extent in outlying other additional provinces such as Northern Cape and the Eastern Cape. And this has resulted in court backlogs. In KwaZulu-Natal, a number of periods where the hard lockdown was put in place have resulted in wholesale postponements of matters on the trial roll, as well as matters on the opposed and normal motion court roll. So that has had an impact, and it's just simply not possible to fit everything in, shifting it even by a year. And in many instances, this is now resulting in cases being allocated dates sort of a year and a half, 2 years down the line, having been postponed as a result of COVID. There have also been court closures as a result of infections, as well as deaths in certain instances. And as much as technology has its advantages, there are limitations. A big one that we would all know about as South Africans is the issue of load shedding. And obviously where electronic devices and internet are down as a result of it, electronic hearings and consultations aren't possible. Another limitation that we've found challenging in certain instances is the assessment of credibility of witnesses. In many instances where we consult with groups of practitioners or nurses, but they're all sitting with masks on, and that makes it impossible to assess responses or reactions to certain questions and the comfort in responding of those witnesses. Another, possibly the worst impact that we've had is we've experienced the deaths of witnesses and litigants as a result of the pandemic. And that's perhaps a cautionary tale and a reminder where you're dealing with that sort of a situation of a new claim and early consultations, to make sure that you take witness statements and have them sworn and filed, just to ensure that that sort of an instance can be covered as far as possible. And that being perhaps the ugliest of the bad component to the consequences or challenges of COVID, onto the funny. I've had a personal situation where, and all of you will know about children and animals, etc., interrupting meetings and hearings, etc. But I had a matter down in the Eastern Cape where we had 4 senior advocates on the Zoom call for an opposed exception hearing. The lady judge was also on the call, as well as about 5 or 6 senior attorneys. And the one senior advocate was struggling to deal with the sound on his Zoom, and so called for his son to come and assist him. And unfortunately for the son and the advocate, I don't think they realized that the video was on and the son was wearing quite a tight pair of underwear, and that was it, and was displayed for all of the participants on the call to see. And as a closing on that issue of the funny, I'm not sure how many of you came across this video, but I think it perhaps sums up the challenges best of all.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to take a look.
Can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that. I think if you click the up arrow.
One wonders whether that lawyer was trying to get the sympathy with the whole cat face, but yeah, that was quite a funny one, Bryce. So some of the interesting cases we've seen in this COVID-19 world, I was involved in a matter for a private hospital group out in the Western Cape. Shortly after the interim order that was agreed between SAFRA and a whole lot of applicants in relation to the use of ivermectin, there was a threat of an urgent application by a patient's son whose mom was in ICU and had been on the ventilator for about 3 months. And he demanded that the doctor that was treating his mom, the physician, provide her or administer ivermectin as treatment for COVID-19. Now, at that point, immediately after that particular consent order, the approved compound of ivermectin, which the hospital groups were seeking to bring in, had not arrived in South Africa. Now, you would or may not know that ivermectin has different compounds for different types of uses. So you have a particular type of ivermectin compound that's used specifically for animals, and then there's some that's used for human use. And this particular gentleman wanted the doctor to administer the ivermectin that he had obtained, presumably on the black market, to his mum as an attempt to try something to deal with her condition. Now, the doctor on a human level was considering it, but the test was whether from a clinical perspective, the doctor felt that the use of ivermectin would have made a difference in a clinical outcome. And ultimately, the doctor was not prepared to put his head on the block to say that he reasonably believed that the ivermectin would have made a clinical difference in the circumstance. Obviously, from a hospital perspective, we didn't want a black market ivermectin to be administered on our premises, given the inherent risk with that particular issue, and potential claims arising from that particular risk. So ultimately, that ivermectin was not administered, and that was the end of that matter. I'm currently dealing with a matter for a private hospital group where a patient was at a particular facility being treated for an advanced stage of cancer. He was being treated with chemotherapy, and he had a whole lot of other comorbidities. That facility had a breakout of COVID-19, and there was a request to transfer that patient to the hospital group's hospital that I act for. The patient was transferred, and prior to admission, the patient had a COVID-19 test as part of the admission protocol, and was initially admitted to the COVID-19 waiting results ward, this particular ward that they put them in. Initially, the test result came through as negative, However, the specialist physicians that were treating him were of the view that given his symptoms, he in fact was COVID-19 positive. And as we know, that the COVID-19 test results are not 100% accurate. And there's also a period of dead time where you could be carrying the virus, but the tests may illustrate a negative result. A few days later, after a second test was done, this particular patient tested positive. Ultimately, the patient passed away, and on his death certificate, it was noted as cause of death, COVID-19 complications. Now, the patient's family have sued the hospital and the doctor on the basis that they say that that COVID-19 was a hospital-acquired COVID-19, and therefore they were responsible for his death, and as a result, they have a loss of support claim. And in my view, they have severe challenges in proving that type of claim, both in relation to the issue of negligence and the issue of causation. So that particular matter is ongoing. And I suspect we will see a few of those matters arise over the next year or two against both practitioners as well as the private hospital groups specifically.
An interesting matter I've been involved in related to the consent to treatment and transfer of a patient with COVID-19. She was admitted to a private hospital and managed there for a period of about 5 or 6 days before she was then transferred to a state hospital due to a funding issue. And it happened in the middle of the first big wave that we had in June, July last year in South Africa. And much of the communication, in fact, all of the communication between the doctors, nursing staff, and the family, because the patient was on ventilation and sedated, took place by telephone. And it's a particularly challenging situation where you're dealing with lay people who perhaps don't understand the situation fully. And you have a situation where you're trying to take properly informed consent from them by telephone around critical issues of treatment and transfer. And this is perhaps just a cautionary tale. Ultimately, there was a letter of demand sent relating to the death of the lady concerned, where it was suggested by the patient's family that the treatment that had taken place wasn't appropriate and had taken place with negligence, and that there was no proper consent to her transfer from the private hospital to a state facility. And fortunately, there was good record keeping around the calls that were made to the family, the times, what was discussed, and that was enough to illustrate that in fact the allegations in the letter of demand weren't quite accurate. And by virtue of that fact, the claim has hopefully been avoided. But it's just a cautionary tale perhaps around ensuring that in this context, where in most instances there's a limited amount of access that patients' families have to facilities whilst their loved ones are being treated, to ensure that proper record keeping of calls to those family members are kept. I am mindful of the time, so I'm going to go quite quickly through another risk that still persists in the present COVID-19 situation, and that's a professional misconduct inquiry against a medical practitioner. And these complaints are initiated by the submission of a complaint to a regulatory body, either by a natural person, and that's most often the patient themselves, perhaps a family member, or even a colleague of the practitioner in some instances, or perhaps by a juristic person. And most often we see those sorts of complaints either coming from a medical aid scheme or from one of the hospital groups. And the regulatory bodies who often receive and deal with these complaints and institute inquiries are largely the HPCSA, the South African Nursing Council, and the Allied Health Professions Council of South Africa. In terms of the HPCSA process, which is perhaps the one that is most often encountered, the power for the HPCSA to institute and pursue those inquiries sits in terms of Section 41(1) of the Health Professions Act. And also in terms of the Act, there's a definition of unprofessional conduct. So that's what the HPCSA would look at investigating under the umbrella of that term. And it's defined as improper or disgraceful or dishonorable or unworthy conduct when regard is had to the relevant profession. And that's perhaps about as clear as mud. But fortunately for us and for practitioners, there is a list of unprofessional conduct that they would consider, the HPCSA would consider investigating, published on its website. And this includes unauthorized advertising, improper relationships, operating without proper informed consent, incompetence around treatment and management, excessive fees, racial discrimination, rude behavior, and perverse incentives and kickbacks, just to name a couple of examples. In terms of the test to establish unprofessional conduct, it is really to compare the alleged unprofessional conduct against the standard required of the practitioner within that relevant profession. And it's important to note in this regard that you're not dealing with having to establish negligence or causation to show unprofessional conduct. And examples of guilty findings or potentially guilty findings include supersession. So that's where one practitioner intervenes in the care or management of another practitioner's patient without the consent or understanding of the other practitioner. And there's no need to establish negligence. That constitutes unprofessional conduct and can result in a guilty finding ultimately against that practitioner. And then a second example would be the carrying on of an improper relationship with a patient whilst that practitioner is treating them. And that can be even with consent. An example that Deniro and I dealt with involved a lady who carried on an affair with her treating doctor. Ultimately, the treating doctor ended the affair, but the patient's husband found out about it and instituted a complaint against him. And even though there was consent as between the parties, it constituted unprofessional conduct because of the nature of the relationship between the treating practitioner and the patient. In terms of concluding inquiry and inquiry processes, it's worth bearing in mind that where you're dealing with a potential finding of a minor transgression, in many instances that isn't something that would be recorded against the practitioner's name in terms of their letter of good standing. So in many instances it may be open to a practitioner to accept this more readily rather than challenge it at an inquiry stage. Criminal conduct, where you're dealing with sexual misconduct or fraud, there may be a criminal component to it, and that might not fall to be covered under various policies. So that's also worth bearing in mind, both from the insured's perspective and as a broker. Legal cost risks, there's can be quite an expensive process to proceed all the way to an inquiry stage in terms of HPCSA professional misconduct inquiries. You have to involve, by and large, attorneys, advocates, experts in many instances, and this can be very expensive. Where appropriate, it might be worthwhile, and this is the final point, giving consideration to an admission of guilt fine or the payment of a monetary penalty. And this can both avoid that litigation cost and also mitigate the insured's risk of an adverse finding where you're dealing with a minor transgression. So you would pay the admission of guilt fine, and that would be by way of agreement and settlement with the HPCSA on condition that there's no endorsement or negative finding recorded against the insured or the practitioner on their letter of good standing or with the HPCSA's records.
I think, just following up and finishing on the HPCSA matters, I think what I2 gets right is that when it comes to the preliminary stage of the complaint, they instruct us to actually do the written response to the complaint. And 9 out of 10 times, you find that when we do the response, we get the matter concluded at the preliminary stage, avoiding a full-on inquiry. I find that 9 out of 10 times, if a practitioner does the initial response, it goes to an inquiry. And that's because, you can't help but get emotional or subjective in dealing with the response if you are the accused practitioner. And, doctors, some of them, have a great opinion about themselves as well, which they sort of put in those responses. And it takes me back to a case I did years ago where the complaint was the lady was unhappy with the doctor's bedside manner. It was a gynecologist obstetrician who during her pregnancy had said to her that, as she put it, she was fat and she needs to exercise, otherwise she poses a risk to both herself and the baby. And the advice was correct. What he was saying is, even if you are in your pregnancy, you've got to ensure that you keep healthy. He was going to put in his response, yes, I told her she was overweight. And I was like, no. You don't want to be saying that. And ultimately, I did the response and we got the complaint kicked off at the prelim stage. So I think the I2 approach is the right approach, in that you should get an independent practitioner to assist with the responses at the prelim stage. Also remembering at prelim stage, the response then can be used at the inquiry to cross-examine your practitioner. So some takeaways from Bryce and my talk is, if as a broker you are going to do business in this particular space, ensure that you understand the insurable risk. Have the conversations with FIA and the team. Read the policy wording. Know what's covered. Understand how the deductibles work in so far as the different categories of cover. Do a proper risk and need analysis for your particular practitioner. So the risk of a GP may not be the same as an orthopedic surgeon or a psychiatrist. Ensure that adequate cover values are taken. Again, dealing with the case of the pilot, that anesthetist, when he put that gentleman on the operating table, he could never have foreseen that this was a pilot earning in US dollars. But luckily, he took adequate cover to cover him for that type of risk, because if you don't have adequate cover values, it can be detrimental to a practitioner's career. As a broker, make sure that you have details of recordal of advice, particularly where you advise the practitioner to take a certain category of insurance or certain cover values, and the insured decided against it because he wanted a lower premium. And then lastly, we live in a world where the professionals, whether you're brokers, auditors, or doctors, you are now being sued regularly for professional negligence. So as brokers, ensure that if you are insuring in this volatile sector, that you do have adequate PI cover for yourselves, and you are aware of your policy terms and conditions. And from Bryce and I, thank you for joining us this morning. And again, thanks to the I2 team for the invite. It's been our pleasure.